happy to be drafted by the Black Archives to moderate this discussion. You've already met our panelists on this discussion of playing through black golfers overcoming the forbidden color barriers. But I think it's important to understand why it was so important to African Americans to finally break that color barrier, and why did they want to even be bothered with it. A lot of times people think that golf is a way to spoil a good walk, but it often is much more to the people who play the game. So why don't one of you gentlemen take that first question on why is golf important, and why did African Americans see integration as being vital?
I'll start. Good afternoon. I wondered why Jim asked me to be on this panel, because I don't play golf that well. although I enjoy doing it. And as I began to take a look at the book, Forbidden Fairways, and do some research around, it occurred to me the very things that Jim said earlier, that golf and other forms of recreation were civil rights issues. If I started saying something, you would all be able to finish it. All men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. All right. So my theory is that golf, among other things, is part of the pursuit of happiness. And our nation, throughout its history, has taken steps to deny certain people the pursuit of happiness. At one time it was illegal, it was unlawful, it was a criminal act to teach a person of color to read. Later on, there were all types of barriers that are erected to voting rights and the like. And so we see vestiges of this that still remain today. And for the purpose of this discussion, I'm going to talk about the pursuit of happiness through litigation to access the means of public largesse. That is, if I want to go play golf and I'm a tax-paying citizen, I should be able to make use of the facilities. That wasn't always the case. We'll start here in Kansas City in the late 30s. The video mentioned Tom Webster and some other people who sued Kansas City for the right to play golf any day of the week. Now, there was a practice. It wasn't a city ordinance, it wasn't state law, it was a practice that white people could play swope number 1, and that black people could play swope number 2 days a week, Monday or Tuesday. And so these gentlemen filed suit alleging that they were taxpayers, that this was a tax-supported facility, and that they should be able to play at any time. Now, bear in mind that since 1896, up until 1954, there was the Plessy decision that said separate but equal. Well, anyone who's been to swope number 1, or what we used to call swope number 2, knows that they were not equal. And the same is true with respect to the facts that were found in the Brown case in the early 50s. But bear in mind, this was way before Brown. And so they were really civil rights pioneers in the sense that they had the will, they had the courage to, in essence, fight City Hall for the right to play golf. And there are a couple of ironies that I found in the course of my research. They went to the Jackson County Circuit Court, and in 1939, one of the circuit judges, Judge Ben W. Turkey, found in favor of the plaintiffs. But the remedy that the court determined was that black people would be able to play golf every day a week at swope number 2. It still did not open up number 1. And anyone who, well, I've said that once already, if you've seen both of them, you know that they're not equal. But that was the first blow. support the issue of full access. Ironically, Judge Purdy was a member of the Jewish faith. And so how the case got to him, I'll never know. But members of the Jewish faith also faced discrimination as well. And in combining their resources, they were able to buy their own country clubs. And some still exist today, although from my experience, they're all open to whoever wants to go and play if you're invited. And so consequently, Judge Purdy, who was near the end of his career at that time, eventually retired, and he was replaced on the circuit court by the first black circuit judge, Judge Lewis W. Clymer. And so I saw a number of connected ironies throughout the research that I did. I can talk more about the efforts across the country involving golf course desegregation. But still, these were before the Brown case in 1954. Of note, later in the early 50s, there was a similar case that was brought against the city of Kansas City to desegregate the Swope Park swimming pool. And I learned in my research that at the appellate level, Justice Thurgood Marshall was part of the case on behalf of the plaintiffs. And eventually, the Swope Park swimming pool was desegregated. Now, I'll talk a little bit later about reactions to these cases, because sometimes the reaction would be, we're going to close the swimming pool. We're going to close the golf course. We're going to lease the golf course to a private entity so that it's no longer public. Or we're going to sell, or in some instances, they were even closed down. So these types of progress setback, progress backlash have been replete throughout our history in many